السلام عليكم ورحمة الله وبركاته. بسم الله والحمد لله والصلاة والسلام على رسول الله وعلى آله وصحبه أجمعين. أما بعد. Today's class, inshallah, today will be the last session for this term, and we would complete our session with the will. But I didn't come today. He was asking about the will since the beginning. Told him we'd allocate us a specific session just for wills. Right. Anyhow, so listen, when we hear about the term will, there is many confusion or much confusion surrounding will. What is will? Taib Allah Azza wa Jal, He mentions in the Quran, min ba'li wasiyatin yusabiha aw dain wasiyah. Wasiyah is translated as what? Will. A will, but the term will, it has what? Many implications. The will itself, we spoke in the beginning, we mentioned in the beginning that when a person dies, there's 4 claims to the estate, and this is the sequence of priority. The first claim to the estate, when you speak about claim to the estate, liability to the estate, the first claim is that of funeral expenses, that is deducted. If no one pays for it voluntarily, that is deducted from the estate itself. The second, we mentioned debts. Alright? The creditors, all the creditors, every single individual, whether it be a company or an individual that the deceased owed in his lifetime, those assets, if it has to be liquidated, let it be liquidated, and what? The debts be paid. As we mentioned, if it means that the entire estate be exhausted to pay these debts, then that is the Sharia, that is the law. Debts are given precedence over inheritance. Alright, debts are given inheritance over precedence over inheritance. For example, a person dies, he left behind say $20 million. $20 million is not inheritance. $10 million he left behind is not inheritance. If after the payment of what? These debts, there's what? There's something remaining in the estate, only then it would go to inheritance. If the man died leaving behind 10 million and his debts are 10 million, there's no inheritance. There's no inheritance. Alright, so that is the debts are the second claim to the estate, and then we mentioned debts of 2 types. Those debts that owe to individuals and those outstanding religious monetary obligations. Alright, unpaid zakah, qurbani, fidya, and these things, right? But this second one, outstanding monetary religious obligations unpaid, alright, that outstanding, right? This would only have an effect on the estate if the deceased, prior to his demise, he instructed, right? He instructed, whether it be what? Verbally, when I die, the fidya, pay my fidya for Miss Salah, Miss Fast, this and that, Miss Qurbani, Miss whatever. He would explicitly mention that, right? Or he wrote it on paper, whatever. It was a directive and instructions from the testator himself before his demise. Only then it will have a bearing on the estate. Otherwise, when the person dies, we cannot say what? Listen, no heirs could say, listen, let's pay the fidya, let's pay for his Miss Fast, Miss... No, he didn't leave any instruction, so that is not taken from the estate. It's not taken from the estate. But yes, if a person wants, if an heir, he wants, he can take that from what? His share of the estate and do that. Or his personal what? Money and do that. Right? But he cannot say, listen, we're going to take it from the estate and pay. No, that would only be what? Jaiz and permissible if there's what? General consent of all the heirs involved. Why? Because this is connected to their rights. As we mentioned, the moment a person dies, the moment he dies, there's an automatic transfer of ownership onto the heirs. When a person is alive, yes, that is yours, whatever you want to do with it. But when a person dies, then all what he owned until his last breath, the moment he dies, it is transferred onto his heirs. And as we mentioned, these heirs are stipulated in the Quran. The heirs are stipulated and their shares are stipulated. So, for us, the living people, all we have to do is what? Physically distribute. It's not for us to see, okay, who is deserving, who is not deserving, right? How much he should get, how much she should get. That is not our job. Allah Azza wa Jalla already what? Specify the heirs and their share. All this is introduction. Remember, this is what summary of the last 4 classes. Okay, go ahead.
So if that the fidya or something that is owed, say could be verbally or in writing. If he writes that as part of his will, is it calculated separately or is it considered part of his will?
Right. So that is what that's going to be answered now. That is the second right, debts, second claim to the estate. All right. So after what? Funeral expenses and debts. After deduction of these two things, you have what you call a net estate. Before was a gross estate. This is what a net estate. The net estate now is divided into 2 parts or 2 groups of people. They have what? Claim to that net estate. The first is what they call beneficiaries. These beneficiaries are non-heirs. And the second part are heirs. So this is what the beneficiary part over here. This is only if the testator, he instructed. So if he instructed for the payment of fidya, it would come from this portion here. It would come from that portion. And that portion is what? It has a limitation of 1/3. Right? I would explain that just now. Right? That has unlimited claim. Unlimited claim to the estate. As for this wasiyah here we are speaking about, that person instructed when I die, that money be paid for what? My fidya, my misfast, my khalas, unpaid zakah. Right, that has a claim. Except that is a limited claim, 1/3. Alright, for example, just say for example, a person died leaving behind $30,000. That is his gross estate. The funeral service costs say $4,000 and the debts $8,000. How much you have remaining from that? How much? 18,000. Right, that's 12. Take away 12, 18. 18,000. And then he made a wasiyah. Right, when I die, give Zaid what this month, give Zaid this amount of money, pay my fidya, unpaid zakah, this and that, whatever. And that whole amount, it came up to $10,000. How much it came up to? $10,000. But if you look at $10,000 as compared to the net estate is $18,000. 10,000 is more than 1/3 of the net estate. 10,000 is what? 1/3 is more than 1/3 of the net estate. 1/3 of the net estate over here is what? 6,000. So that part being what? Wasiyah, that would only 6,000 will be financed. Right? 6,000, any worth of any wasiyah, that would be financed from the estate. The other what? 4,000, it would not be taken from the estate unless all heirs they give consent or any heir want to voluntarily pay for that. Why? Because it has the maximum claim that has is 1/3. And after that, now this is where the inheritors come in. Right? So after the will, that wasiyah is executed, whatever remains, this will be for the heirs. But understand, there would never ever be a situation where after executing the wasiyah and the will, there's nothing for the heirs. Why? Because the will, that wasiyah over here, that will, it only has a limited claim, 1/3 of the net estate. And we explain that a little more details just now, inshallah. Alright? So if we look at the deceased, right? If you look at the deceased, there's what? From the 4 rights, he only has what? Jurisdiction in one of the rights. He has no say in what? Funeral expenses, for example. If he dies, he says, listen, if I die, don't take any money from my estate and do my funeral. He doesn't have that authority. If someone does it what? Voluntarily, all well and fine. No one to do it voluntarily, it must be taken from the estate. So he has no what? Jurisdiction over that. He has no say in that. Secondly, he has no say in his debts. If I die, you see Zaid, don't pay Zaid no money. I owe Zaid X amount. But if I die, don't give Zaid anything. He cannot do that. Even though he has it in writing and stamp, he cannot do that. Right? That is null and void. So he has no what say in that. And thirdly, he doesn't have any say as to who will inherit. Understand the inheritance part over here is that last chunk. He doesn't have what I say as to who would inherit. He cannot say, okay, my son, my big son would inherit. The one that given trouble, he will not inherit. And this daughter already married and what, she doesn't have to. No, he cannot say that. Right? This, as we mentioned, these heirs are already stipulated by the Sharia. Their share already stipulated by the Sharia. So what he has what? He has jurisdiction over this 1/3. 1/3 of the net estate, which is called wasiyah. Right? Which normally translated as a bequest, a will. He has say in that. When I die, give Zaid $5,000. Give Omar this amount of money. Right? Yes, so that would be possible, but it is restricted to 1/3 of the net estate. Give it to what? Give 5,000 to what? BIC Masjid. Give 2,000 to this madrasa. Give khalas. Once it's within that 1/3 of the net estate, it will be executed. And this is what he has say in. Otherwise, in his lifetime, he can give whoever he wants to give. Right? But once he passes away, and this was in his property, his possession, until his demise, then what? The moment he dies, that is an automatic transfer. Right? So yes, in an estate, it doesn't necessarily, that factor of a will doesn't necessarily have to be there. That would only be there if he instructed. Right? He have that, this is his directives, when I die, so. If he had no instruction, he made no wasiyah, nothing like that, right? No, so there's no will in that. So you have funeral expenses, you have debts, and you have inheritance. After that, the whole, after what? Funeral service expenses, debts, then whatever remains, the entire net estate would go to the heirs, right? It would go to the heirs. Go ahead.
Includes everything like house and land and car.
The value.
Right? So you can't say, well, if you get the house, they buy for it, but child or that kind of thing, it has to be limited to that.
Understand, when we speak about this particular wasiyah here, will, we're not speaking about heirs. These are non-heirs. As for the heirs, they have a share of inheritance. Right? In our local normal language, we consider inheritance to be everything that the deceased left behind. No, in the Sharia it's not like that. There's a difference between inheritance and wasiyah, which is translated as will. Right? The will, the last will and testament, we're going to do that inshallah. Right? That legal aspect. Right? But here you have a difference between what? Inheritance, and you have a difference between will. That is why you hear the hadith of the Prophet لا يرث المسلم الكافر ولا الكافر المسلم. A Muslim does not inherit from a non-Muslim, nor would a non-Muslim inherit from a Muslim. That is inheritance. That doesn't speak about will. Why? Because you can make a will to a non-Muslim. A non-Muslim can benefit from your estate by virtue of being a beneficiary and not an heir. You could make make a will that would allow your neighbor who's a Hindu or Christian, right, to benefit from your estate, right? But he would not benefit by virtue of being an heir, right? He'd be a musalahu, that person whom a wasiyah was made to, right? So there's a difference over here. He's not inheriting are what for the heirs. Only heirs would inherit. But this what? 1/3 of the net estate, that person whomsoever he makes wasiyah for when I die, give Zaid $2,000. When I die, give Omar this, that, right? So yes, that would be executed so long as it falls within 1/3 of the net estate.
So the wasiyah cannot go to heirs.
Wasiyah, no wasiyah to heirs, right? The Prophet ﷺ mentioned la wasiyata li warith. Why? Because the warith, the heirs, they already have stipulated shares, right? This is what they already have stipulated shares. So if you have to make a wasiyah, then it would not be for what? Any inheriting heir, right? Any inheriting heir. So listen, you have, within the heirs you have what? Inheriting heirs, non-inheriting heirs. Why? Because in the presence of what? In the presence of some heirs, their presence would deprive fully or partially other heirs. For example, as we mentioned, if a man dies, he leaves behind a son. As we mentioned, son is what? King in inheritance. He leaves behind a son, then that son would eliminate all the siblings of the father. So no sister, brother going to inherit. Right? That son would eliminate all grandchildren. No grandson, no granddaughter going to inherit. No uncle, no aunt going to inherit. No niece, no nephew going to inherit in the presence of that son. Right? So that person, if he has a son and a grandson, that grandson would not be an inheriting heir. So what he can do, he can make a wasiyah for the grandson. Right? The son would inherit his portion, and the grandson being a non-heir, he could be on that, a wasiyah, and a will could be made to him. Right? So the thing about a wasiyah, what it has no, who can receive it is a broad what? A broad thing. Alright, it's not restricted, but it could be Hindu, it could be what? Hindu, Muslim, Christian, religion doesn't matter there. Alright, religion doesn't matter. Once it's for, not a evil cause. Right? Like when I die, a person say, listen, when he dies, he say, listen, take this money and send it to Israel. No. Khalas, that would be null and void. Right? Take this money and we can build a temple with it. No, that's null and void. Right? But if you say, take this money and give it to what? To Shiva. Just say, right? He's a Hindu, that's his neighbor, and they're good. Right? Yes, that would be valid. Right? So this, go ahead. No, go ahead. It's on the last session, so go ahead.
Alright, so when we talk about writing a will,
right.
Not about writing a will to say, well, okay, so
right, so we come into that just now. So most people they understand, yes, a will is something shari'i. Yes. And they believe that, listen, when we die, before we die, we need to have a will. Right? But there are two aspects to that. Understand? The will that you need to have is a shari'i will in sync with the laws of the land. It's not just to make a will. When I die, my son going to get this, my daughter going to get that. You cannot say what your son and daughter are going to get. They are your heirs. So what you can stipulate here, look at the Sharia shares. Alright? The Sharia shares. For example, that person what? He just has what? A son and a daughter. That is all the heirs he has. So if he's making a will and he wants that what? His children benefit from what? His estate, these children after his demise, then all he can mention, when I die, 2/3 of my property, it would go to my son, 1/3 would go to my daughter. That is in sync, that is in line with what? The Sharia shares. Alright, so if a person making a will, it must be in line with Sharia. He cannot say when I die, my son going to get 50%, my daughter going to get 50%. Right? Even though the will may be valid according to the laws of the land, that is an invalid will according to the Sharia. Why? Because if after your demise, then means what? The property remains with you until you die. It means that the moment you die, that already transferred, and it transferred the ratio 2-to-1, right? The son going to get 66.66%, and the daughter going to get 33.33%. So khalas, your will now in writing must be in line with that. If it is not in line with that, it's a null and void will according to the Sharia. Right? So the recipients of the will, they could be what? Individuals, institution, righteous, any cause, alright, non-inheriting heirs, and non-Muslims also. Unpaid zakah, if you're looking at what? Outstanding religious obligation, monetary obligation, unpaid zakah, obligatory hajj. Hajj was obligatory upon a person and he didn't what? He didn't perform the hajj. And he made wasiyah, when I die, fulan, this person will perform hajj on my behalf. Then khalas, that will be executed so long as it is from 1/3 of the net estate. More than that, it will not be executed unless the heirs, they give general consent.
So we talk about just about the son and the grandson, and put the grandson in the will. What happens if the son passes away before the father?
Right, so if the son were to pass away before the father, then the grandson will be an inheriting heir. So that will be null and void. He will be an inheriting heir. Right? Understand? Whenever a will, when I speak about a will here, we're speaking about 1/3 of the net estate. We're not speaking about that will, that last will and testament. We're not speaking about that. We're speaking about that will, which is what 1/3, not 1/3, that is a portion of the net estate. Alright? So anytime a will becomes void, it goes back into the estate. Alright? It goes back into the net estate, and the beneficiaries of that would be the heirs. Huh? No, that is why it's important that what? Wills be what? Renewed. Right? Wills you have to what? Renew it. Otherwise, if you leave a will like that, yes, it will be enforced. It could be enforced. It will be legally binding in the courts here in Trinidad. Yet, even though they're not Sharia compliant. Alright? Mm-hmm. Uncle wasn't here the previous classes. He wasn't here the previous session. This is session number 5. All what they mentioned was dealt in details. But listen, for a person to be an heir, right, there are 2 factors: blood relation and being a spouse. That is it. So once you that person is a qualified heir, and that qualification is showed blood relation or being a spouse. So that is your son, right? You don't look at the description of your son. If he was obedient or disobedient and what he does, and if he's living with you, he's not living with you, you never see him in your life, right? Wayward, wicked, whatever, all this, it does not matter. That is your son, you would inherit. Right? Say somebody else took care of you, then what? He adopted what? A child. Right? And that child took care of you, from what? Straight until your old age, everything. That child is not an heir, right? Because no blood here. So that's what we mentioned. Listen, if you want to give in your lifetime, right? If a person wants to give, then give in your lifetime. If you give in your lifetime, then what? You're not restricted to any of these shares here, right? In your lifetime, you can give your daughter more than your son, right? If you think she's more deserving, you can do that. You can give anybody, right? That is your wealth. Right? قَدِّمْ لِنَفْسِكَ خَيْرًا وَأَنْتَ مَالِكُ مَالِكُ. Do goodness for yourself when you are the owner of your wealth. The moment you die, you're not the owner of your wealth. So when people do this for your sadaqah jariyah, whatever, that they do it from their wealth. Right? Do something from your wealth. Right? So in inheritance, once a person is what? You just look at that blood relation and being a spouse at the time of demise. Right? Not all the time. In some cases, not all the time. When you say a girl, you look at the relation to the deceased. Right. Right. There are certain understand. There are certain heirs, right, that would never be deprived. Alright. You have many heirs, but there are certain heirs that would never ever be deprived of inheritance. That is the father, the mother, the wife, or the husband, the son, the daughter, right? Other people what may or may not inherit, right? Or they may inherit fully or partially, right? But these people here would always inherit. Nobody can what? They cannot be deprived of inheritance. Some may be partially deprived, right? Many heirs, they have what they call a larger share and a smaller share. That larger share, normally in the absence of certain heirs, in their presence, they would get the smaller amount. But these heirs I just mentioned, they would never ever be deprived of inheritance. Right? The grandfather could inherit, right? But the moment what? The father there, the grandfather would be deprived. The grandmother could inherit, but the moment what? The mother is there, the mother of the deceased is there, the grandmother will not inherit, and like that. Right? So these what? The spouse the children, and what? The mother and the father, these will always what? Inherit. They cannot be deprived.
When you say the mother and the father,
You connect everything to the deceased, right? The mother of the deceased, father of the deceased, right? Daughter of the deceased. Because a person will say, listen, if a son comes to bring the case, right? My father died and left behind, okay, me and my sister, right? Me and my sister, right? So you don't check the inheritance or what? A brother and a sister? No, in relation to the deceased. It is a son of the deceased and a daughter of the deceased, right? Alright, so now a person what? He made wasiyah, and in making that wasiyah, understand that wasiyah, that will here we're speaking about is what? That limited claim to the net estate over there. So he made what? Listen, when I die, he made what? It left instruction for the full, to perform hajj on his behalf, to perform any unpaid, to give unpaid zakah and fidya and a whole kafarat and sadaqatul fitr and qurbani, and he even mentioned, listen, give this to the madrasa, give this to the masjid, give this to the poor. And you know what? In more than what? In more than 1/3. Alright? In more than 1/3. So what would happen? Right? Those wasiyah, those bequests that are of a mandatory nature, right? That will be given preference. Right? For example, if he has what? Unpaid fidya, zakah, this and that, that would be given preference over what? Given to the masjid, given to the poor, given to the madrasa. Why? Because the latter part over here, good, very good, yes, but it is optional, it's not obligatory upon him. That is not obligatory. So if the 1/3 cannot finance everything, then priority will be given to those that are obligatory. Alright? And also, I know the question you're going to ask, even if within the obligatory now, right? The amount that he mentioned, even though all is obligatory, still cannot be financed. Right? There's more than 1/3 of the estate. Then what happens? Those instructions or those wasiyah that are more beneficial to the poor, that would be given precedence. For example, what? Fidya. Who are the recipients of fidya? Recipients of unpaid zakah, qurbani, right? It will be the poor. So that will be given preference over the performance of hajj. Right? So as we mentioned, who can what? Be what? Beneficiaries of the will and the wasiyah, not inheritance. Right? It could be what? Muslim, non-Muslim, Hindu, Jew, Christian, atheist, agnostic. Right? Non-heirs. Understand? If it is given to an heir, why non-heirs? Non-heirs, they have their share, right? If it is made to an heir, understand here, generally yes, that part is invalid, unless, right? Unless the heirs themselves, they give consent. You understand? Why? Because it belongs to them. If the will becomes invalid, that portion, what? It goes back to the estate. It belongs to what? It belongs to the heirs. So if the heirs say, listen, a man died, left behind what? 4 children, right? Left behind 4 children, and he made a will, forget the inheritance, a will to what? The last child. That is the obedient one, that one who stayed and did all the khidmah, right? He made a will, meaning, this is apart from inheritance. He made a will for that last child. That will is null and void unless the 3 other brothers, they give consent. Why? Because it's their haqq and their right. And if they're willing to forego their haqq and their right, then what? They have that. Right? They can do that.
So we always thought that the onus was on the person himself to write a will to share it up among the family.
Right. Write a will. That is what? Write a will, but that will must be in line, in sync with the Sharia. Right? The Sharia shares. Right? The Sharia shares. That is why we mentioned ever so often it should be renewed. Why? Because somebody else might come in new in the family. Somebody might die. Right? Or within that 1/3 over there. Right? might want to change that. Alright, you could do all that.
A person also make a will saying that when I die, I will fulfill. Like, I give them all this to these people, but only when I die, then they will be able to access it. They'll have to do what they
No, that is a will. Understand, a will is not in your lifetime. Understand, listen. If a person, right, for example, he says, listen, when I die, give so and so that. I give so and so that. That is what? Once you attribute it after death, that is a will. Once you attribute it after death, is a will. Right? And if it, understand the will here we're speaking about, until now we're still speaking about not that will which is the law we're speaking about, the last will and testament, not speaking about that. Right? We're speaking about that will which is part of the net estate. The four rights connected to the estate, funeral expenses, debts, will and inheritance. This will here we're speaking about in this context. Right? If a person attribute the transfer of property of his property after his demise, it is what? A will. So a person tell his son, listen, when I die, that car is yours. Right? When I die, that car is yours and this land is yours. Right? He attributed to what? After his demise. That gifting after demise automatically becomes a will. And him being an heir, an heir of the testator, that will is null and void according to the Sharia. Why? Because he's an heir. He has his share already stipulated. But if you want, son, this is yours. Son, I give you this in your lifetime. So it's a gift now. So if you were to die, right, that would not be part of your estate. That already left your ownership.
So if the father do and put the son name in this portion and two of his name in this land and two of his name in this account, this son name in this account and this one in that account, right? So this he put in his name in it because this is for you, but I still want to have access to it until I die, right? So now when I die, the money or the property, it will be on the son name or whoever name he had put it because two of them was in it and all one died.
Right, so that needs to be clarified in the lifetime. Understand here? A name or a registration does not necessarily show ownership. Right? We need to understand that. You have your wife's name on the bank account. Right? And why this one so crystal clear and you can shake your head and answer. Right? Your wife's name in the bank account, does that mean ownership? Right?
But she could go on to
Right. She has privilege to the account. She has privilege to the account, right? And listen, and you can take how much you want to be my wife, I give you that privilege. But here now, do you own the account? Does every cent in the account belongs to you? Then we have a problem. Right? We'll do like that. No. And if you say ownership, then okay, in what ratio? 50-50? Right? But it's a hard question, right? Why? Because there's no ownership. They just have privilege to the account and they can take how much they want and spend. Yes. But is there ownership? Alright? So this has to understand, this connected to what? Hajj, Zakah, Qurbani, everything. Ownership. Remember that last session we had? Hey, who owns? What do you own? Right? So your name being in a paper, your name being in a document does not necessarily show ownership. Right? The person gives it, khalas, he can give without your name even being in the document. Right? A Shari'i transfer doesn't, there's no witnessing and what documents, right? So ownership could transfer without registration, without your name being in a document. And similarly, your name could be in a document and doesn't necessarily show what? Transfer of ownership. Right? So, let's check with you. Understand? Most old people, right? I mean, our people then, right? Rare you would find what? They're transferred in their lifetime. Right? They hold on to that. Right? No. And they know what they have, how much they own. Right? But see, when I die, all I go sort it out. Right? So what has happened when they die? The whole family come together and cry and hug up on this and that. And within the month, he not talking to he, this one not talking to that one, because everybody what? They want the inheritance. They want to sort out the inheritance. And what? They have too much, there is so much ambiguity, right? That would lead to what? All these what? Conflicts, never ending conflict. Alright? So if we listen, if we want that the family, the children, the grandchildren, everybody would be in one, be together after our demise, we set the precedence. We do the thing proper. We don't say transfer, but still mention okay. Right? Because sometimes my father would say, you see what? When I die, right, that is yours. And he tells 30 sons the same thing. But my father tell me that. But you know, so one property he gave it to 3 people, and you know. So make things really clear, crystal clear. In your lifetime, you could transfer to whomsoever you want. You can give to whomsoever you want without what? Adhering to these specific shares, right? But as I mentioned earlier, understand there's no virtue, right? It just transferring your property to your children, right? I mean, if they're in need, we understand. But if they're not in need, if you what? There's no virtue or distributing your property before you die. You understand? Let's have things clear. Because what's going to happen? You're going to live in somebody else's property, right? And if you give everything, you know what? I give it to my big son or my son, right? And if you give it to him, it belongs to who now? The daughter-in-law, right? So if you have no problem living in what? Understand, if you give it to the son, he could do whatever he wants with it. He can sell it, but you sell the thing, but that is mine. How you mean? If you give it to me legally, it's mine, and according to the Sharia, it's mine. You can't give me something and tell me what to do with it. You could probably advise me what to do with it, but the moment I become the sole owner, right, I could do whatever I want with it, right? So understand, there's no virtue in a person just giving him all his property in his lifetime, right? You have excess, he wants to give, no problem. But when he dies, understand, this is inheritance. When he dies, his property would be distributed according to the laws of what? Inheritance. Alright? A person will say, no, I'm going to distribute my inheritance before I die. Yeah. You cannot distribute your inheritance before you die. Why? Because inheritance would only come into play after death. So whatever you distribute in your lifetime in the name of inheritance, that is a gift, a grant, a donation, whatever you want to call it. Right? But even if I give everything, yes, even if you give everything is a gift and a donation. So then what remains then? And the clothes you have on, that is inheritance. The shoes that you're wearing is inheritance. The chair that you sit on is inheritance. Right? Whatever you own, whether it be what? A pin or the pin factory, that is inheritance.
So there might not be virtue in distributing while you're alive, but it could save plenty.
Yeah. Because you know, there's a certain property you don't need it again, right? You don't need it, and yes, you intended that it go to the children. So you know that part, we must sort it out. Right? That part, we can sort it out. And the sisters, they have a discussion, they have questions, they can probably send it to you.
Sisters, are there any questions?
They have in their own class, anybody? Right, so let's go quick to this the will.
Talk about the like joint accounts and that is kind of thing. What about this saying that the sisters have that what's yours is mine and what's mine is mine?
That's probably a romantic statement. I don't know, it's not Sharia statement. Alright? Understand, what is yours, what is hers. Simple as that. That is before marriage, within the marriage, after marriage. Before death, after it is the same. A woman what? She enters the marriage, right? What is hers remain hers. Unless what? She transfer ownership. What is the husband's remains the husband's, right? Unless he transfer ownership. Right? What is mine and what is yours is mine. That's probably, But listen, if you tell her that what is mine is yours, then you give it, you give it to her. Right? But listen, what is yours is yours. What is hers. That is before marriage, after marriage, it doesn't matter. Alright? Unless there's transfer of what? Ownership, by gifting, selling, or whatever. Alright? So here now we go to what? The last will and testament, which is known to what? When we hear the last will and testament, this is what we understand, right? This what? Is a legally binding document that gives instructions as to how the estate of the deceased will be distributed. Here we're speaking on legal terms now, right? The will, and this term over here, not the context of what? 1/3, or that part of the net estate. When we speak about will, you make your will, you do what you will. Okay, this is what people understand here, right? The legal aspect. That is what? Instructions from the testator, the deceased, as to how his estate would be distributed after his demise. Understand here? This is one thing. A person in his lifetime, he may talk and he may say certain things and people will take him on. Right? But listen, whatever he leaves in a will, that is hakim. That would take precedence over anything. A person writes in a will, my entire estate will go to what? That man, some person, right? Non-heir, non-relative, khalas, no connections, total stranger, then the law of the land will enforce that. Right? That is a will. Right? Whatever person what he writes, right, upon his demise, how his estate will be distributed, that will take precedence. So if you look at will, on that aspect, you could have what? A Sharia compliant will and a non-Sharia compliant will. Right? A Sharia compliant will be that will and last testament that is made in accordance to the laws of inheritance. Right? It is made in accordance to the laws of inheritance. For example, we go back to that person, right? We go back to that person who has what? A son and a daughter. Right? And there's all the heirs he has, a son and a daughter. So that person now, if he's making a will, it would be what? 66.66% of my property would go to. Mentioned also after the payment of what? Debts and this and whatever, the residue of the estate will be distributed in this ratio 2-1. Right? So that will here now is what? A legally binding will, according to the law of the land, and also what? Sharia compliant. Alright? You understand? If he mentioned in his will, last will and testament, and when I die, my entire property would be distributed amongst my son and daughter equally. Right? Equally. So that is a valid will according to the law of the land, but invalid according to the Sharia. That is a null and void will. Alright? That is a null and void will. Alright? So listen.
When somebody does something like that, well, it'll pass according to the law of the land, but then you will be accountable.
Yeah, so listen, even what the law of the land, the court what? Rules like that. Understand? The court cannot give a ruling contrary to the Sharia. When people say they have their papers, and what kind of papers they have? That is mad papers. If you have a paper contradicting what? The laws of the Sharia. People have what? Muhammad and Ali and Khan and all these Muslim names license to sell liquor. Who give you license? You have papers. It's mad papers you have. Why? Because according to the Sharia, you cannot do that. Right? So even though what you have a person doing that, right, he's not allowed to do it. So just say the court, in this case the son and the daughter, the court were to rule 50-50, right? What the daughter has to do is what? What is in excess of what? 1/3, give it to the son. And she doesn't do that, then she would be held accountable. And she cannot say, listen, I do this illegal way, right? I have my papers and this is mine. No, it doesn't work like that. Alright? And understand, it's important, right? This last will and testament that we mentioned over here is important. Why? Because listen, that is the duty of every single Muslim living in a non-Muslim country. right? A person failing to do that, what would happen? He would leave what? It would leave what? The law of the land presiding over how his estate would be distributed, right? And the law of the land, what? They have what? Laws of succession, how estate would be distributed upon the demise of a person. And these laws are not, according to the laws of the Sharia. So a person, what? He needs to have a will. Everybody needs to have a will, right? And when you speak about a will, a Shari'i will, right? Everybody needs to have that. Otherwise, it's not okay. When a person has a will, whoever he mentions there, right? So I have my will. So when I die, good. No, that will that you have, right? It must be in sync with the laws of the Sharia. So a person already make out my will, now my daughter going to get this, my son going to get that, my wife going to get this, right? And stand by law and everything. That is not a valid will according to the Sharia. It would only be valid if what you stipulated, right, is in sync, is in accordance to the Islamic shares in inheritance, right? So many times, many people, they have what? If you ask them, they have the will. Yes, I have my will, but if you look at most of the wills, 95% of the wills that the Muslim people they have, right, is invalid. It is invalid. Why? Because they stipulate, they specify heirs and they stipulate shares. That specification and stipulation is only from the Sharia. As we mentioned, when a person dies, his estate is automatically transferred. It's this specification is automatically transferred. So your will now has to be in line with that specification. Otherwise, it is null and void. B? Understand? Brothers and sisters of the deceased. You look and see if the person has no children, right? He has no children, no son, no daughter, no granddaughter, no grandson, any paternal grandchildren, and he doesn't have what? A father or a grandfather, then what his siblings could inherit. So if the person has a daughter, yes, siblings could inherit with the daughter, not the son and grandson. Imam, last time they gave him 5 wicked children. And that's what they do.
What I want to know is how do you do this in practical terms? Okay, like using the Imam as an example. Say I have one wife that we know of.
Understand, this part of the course here, right? We didn't deal with what? Calculation and distribution. Otherwise, the second part of the course, which we're not doing over here, right? This would have every single heir, how much that heir would inherit in the presence of whom, the conditions for what inheritance, and actually distributing the estate, right? The actual distribution of the estate. And as you mentioned, this would require a little more effort, right? But we need a project and everything for that, and we'll try to bring the second part soon, inshallah. And listen, you don't have to go no madrasa, you don't have to be no alim or no sheikh to do that, right? And when they finish, you'll be better than that, you'll see, right? It's very simple, very simple.
Here, okay, a wife and a daughter. He have like brothers as well. So obviously whatever he would want, like the house and land, he would want to pass it on to his child. How do you go about doing like that, something like that now to ensure that the child get it? I mean, he had good brothers. Let me say he had miserable brothers, and when he passed away, they want to come and fight.
No, that's you leave a Shari'i will, right? A Shari'i will is what? If a person dies leaving behind, for example, a wife, a daughter, and a brother, how this will be distributed according to the laws of Sharia? The wife will get 1/8 of the estate, the daughter will get a half of the estate, and the remainders will go to the brother. Right? But if you understand, if a person dies without leaving a will, he dies intestate. Right? Intestate, a person what? A person dies intestate, it means that the law of the land would preside. Right? The laws of what? Distribution according to what? The law of the land, that would take effect. So if a person doesn't leave a will behind, this is what's going to happen. So that is why, understand, let me tell you something again. You don't need to go by the lawyer to do a will. We can do the will here. Right? You don't need to go by the lawyer to do a will. Right? If sometimes you go to if you want to go to the lawyer to do the will, right? And what? 99.9% of the time that lawyer doesn't know the laws of Sharia. So he will give you a will that is valid according to the laws of the land. Right? He would give you what you want in the will. Whatever you want, he would put it for you. Right? We don't want that will. We want a will that is what? According to the laws of the Sharia also. So these two aspects must be there. It must be Sharia compliant and also what? In sync with the law of the land, so it can be executed legally. Right? So it's the responsibility of each person to make the necessary arrangements to ensure that his estate is distributed according to the laws of Sharia. And that is only possible. Listen, if you have what? Any real, how you call it? A righteous executor. They mentioned this, and when I die, I entrust the distribution of my estate. You need to this executor here, according to the laws of the Sharia. You put trust, you trust him that he will do that, or that institute will do that, or you put it on paper. Right? Look and see. Right? And this is normally what? From the first session, the homework I normally give the students. Look at your heirs. Right? All your family members understand that. Let's write it down. And the other classes will see, okay, this will not be, this will not inherit, that will not inherit, that will not inherit, until what? Your heirs remain. And from your heirs now you would see, okay, each one how much they would inherit. Right? So khalas, if you look at you, right? You're looking at Zahir Badi, right? No, listen. That doesn't matter, right? It doesn't mean the more children you have or the more family you have or the more wives that you have, it's difficult. So listen, it doesn't mean that, okay, well I thought it was difficult, that's why I have one. If I thought it was easy, it doesn't mean that, right? Allah Azza wa Jalla, in khiftum alla ta'adidu fawahida. Listen, the share of the wife, for example, if you have one wife, two wives, three wives, four wives, they will equally share in that amount allotted to the wife category. So if you have one wife and you have children, understand children will affect the shares of what? The spouse and the parents. So you have children, the spouse, the wife will receive 1/8 of the estate. You have no children, then the wife will receive 1/4 of the estate. So whether it be one wife or multiple wives, they would what? Equally share in that amount any allotted to that category. So it doesn't matter. It doesn't mean, okay, more people is more complicated. No. Alright. Listen, even what? Because what? We live in a non-Muslim country, a person would say, listen, well, I have nothing, I own nothing. Right? So there's no need to make a will. No, that's still important, even though you own nothing. All you own is yourself. Why? If you come from one, these questions always coming in. Hey, you could come down by how do you call this place, this funeral home, boy? By budoos and das and do a janaza. Why they're gonna cremate the body? A person accepts Islam, a non-Muslim family, right? He passed away. Who has what jurisdiction over the body? The family, unless he stipulates. Understand now? This is what I will, the benefit of a will. Unless he stipulates, when I die, I want what? That my body or my funeral be in accordance to what? The laws of the Sharia, Islamic burial and funeral and like that. If he doesn't specify, then what? According to the law of the land, the family has rights to the body. Many times you see janaza was in budos and das and then going to cremate. He didn't leave anything behind. Alright? He thought, okay, I don't have an estate, I don't own anything, right? But this is the importance of what? Making out a will, whether it be for monetary purposes or what? Non-monetary purposes. So to avoid what? Intestacy. According to the law of the land, if a person dies without a will or without a valid will, one is leaving a will, but understand here, for that to be enforced, the wording must be proper. So you just can't sit down and make a write up a will. No. Yes, you're right, but you need what? A little what? Little assistance, right? The wording must be proper, right? So a person can have a will, but if that will is null and void, right? Even what? Legally null and void, it will not be enforced. So if a person dies without a will or without a valid will, he dies what? Intestate. This means that his wealth will be distributed according to the laws of the land. We want that when we die, our estate be distributed according to the laws of Sharia. So when we are alive, we can put that in place. Alright? So in preparing a will, there's what? Two important factors. One is being what? Sharia compliant, and also what? It meets the legal requirement. Alright, it meets the legal requirement. And as I mentioned, listen, you don't have to what? Go by a lawyer to make out a will, right? You could do wills over here just to make out wills here. Alright? And you have your wills and you keep it, right? And you renew it if there's need for renewal, right? If there's alright. Understand about a will, another thing about a will, right? You could, when you speak about a will, okay, when I die, you go back to what? The aspect of the will being a part of the net estate. When I die, you know, give Zaid $10,000, give Omar that, or give this donation. You can cancel at any time, right? And that could be cancelled verbally or in written, except that what? If you cancel it verbally, right? But you still have it in writing. That what? That the law of the land that would take precedence. So even if you cancel it verbally, yes, a condition yet would that would suffice. But if you cancel it on what? Paper also, and renew that will, right? Revoke all wills and what? You could renew that will. Right, so we have this concept over here. This one thing I want to clarify. Right, this one unpaid missed salah, missed fasting, missed fast. Right, so many a times people think that okay, when I die, that would come out from my estate. That would be paid from my estate. All my the fidya from my what? Missed fast or missed salah. I would give instructions and that would be taken from my estate. Right? Understand? It doesn't work like that. A person, if he has missed salah and missed fast, it is obligatory upon him to do the qadha in his lifetime. This what we're speaking about is what? Hey, this is perchance that person dies before doing it. It's like, okay, he has the option to do qadha or pay fidya. He doesn't have that option for fasting. I mean for what? For salah. He doesn't have the option for what? You need you need salah. If you have qadha salah to perform, you don't leave an instruction. You say, when I die, I have what? 150 qadha salah. So fidya for 150 salah. It doesn't work like that. You do your qadha, and if you happen to die, right, and you still have qadha salah to perform, khalas, it will be taken from the estate, right? So it's not an option a person has. As for fasting, yes, understand? If a person what? He would only pay fidya because he cannot fast in his life again. Understand? This is the only time a person would have to pay fidya for fasting. Yeah, I fast in this month of Ramadan and so I'll pay fidya. Instead, you don't have the option. Right? A person doesn't have the option to fast or pay fidya. Fidya is only for a person who cannot fast for the rest of his life. Right? So even a pregnant woman, okay, she's given concession, right, if she fears for her life or the life of her child, to delay the fast, but she will have to make up for it. So there's no even fidya for that. Fidya would only be for a person who has such a fatal or a chronic illness that would continue with him until he dies, and that illness will prevent him from fasting. So you know what, khalas, he pay fidya because he cannot fast. Allah Azza wa Jal mentioned for iddatum min ayyam ukhar. Right? For a traveler and a sick person, then he would what? Fasting in better days. But this person who has a chronic illness, he's not going to find better days until he dies. So he would what? Pay fidya for fasting. As for salah, understand? A person what? Even if he has to lie down and perform salah, he will have to perform salah. Right? A person would perform salah, continue performance until he becomes what? Unconscious, or he cannot even nod his head. If he cannot do that, then khalas, no salah. But once that person can do that, then he would have to perform salah. Nabi Isa mentioned, Sallu qa'iman fa lam tastati fa qa'idan fa lam tastati fa mustalqiyan. Perform salah standing, if you cannot then sit, if you cannot then lie down. Right? So if a person had some qadha salah to perform when he was healthy, right? He didn't perform salah for the whole year, and now this person is sick on a bed. Right? Khalas, he could do qadha for that salah by just moving his head, perform salah in that manner. Right? So it's not, understand, it's not an option. Right? A person should try to what? Do all his qadha in his lifetime, and if he happens to die with what? Any qadha salah still in his account, this is where the fidya comes in. This is where the estate, the wasiyah comes in. The same as sadaqatul fitr. The same value of sadaqatul fitr.
So for every salah, one fidya?
Yeah.
can take the fast.
Every salah, every fast.
So
No.
using myself as an example.
Uh-huh.
Now generally, most times anyway, quite common that like I have one house, one piece of land, right?
They disclose all your property and assets here in this recording. Good. And it's put on YouTube?
I have 4 children, but generally people is trying to share things with the children. So like if you have one property and one house,
Uh-huh.
you know, as your other children grow up, you try to help them build a house too. So then they might have 3 of them living in their own house, and one you expect, well, you know, when you pass on, you take over the house you're living in. So how do you facilitate now that this child will get this property and house after you pass away, and not that after you pass away, the rest of them who already had a house and they want to fight for this one now and see whether they had a sell it and
No, understand here, right? That's a wrong terminology we use. Fight. You normally fight for something that is not really yours, or fight for something that they're not going to fight, right? It belongs to them. Understand that? It go back to the same principle. Once it remains in your ownership, right, it becomes part of the estate. Being part of the estate is that what is connected to the rights of all your heirs, right? Whatever you give to them, these other children, right, in your lifetime has nothing to do with your estate. It becomes theirs, right? So if this particular son now you didn't give, right, then it remains in your property. Then if that is the case, it will be part of the estate, and all of these heirs would have share take, alright? So now what you can do is what? In your lifetime, you can give half of it then, right? Give half of it, alright? There's this one aspect here we didn't do, right? Because of the restriction in time. Estate could be distributed based on mutual consent also, and not necessarily in accordance to these specific fractions, right? For example, listen, we mentioned that earlier, right? A person he dies, same scenario here, 3 children, you already sort them out, and there's this one, right? There's one child, he's still living in the house of the parents, right? So listen, they can mutually decide, listen, you don't have a house, so listen, remember each son or each child would have share to that estate, to that house. So what can happen? This child who didn't have a house, right? They can mutually agree, listen, I would take the house and my share to that land, that vehicle, that property, I would forego it, or I would trade my shares, right, there for the share in the house. The problem would arise when the child, he want this, he want that, he want everything, right? He doesn't want to compromise. So say, listen, I don't have a house, but I have shares in the land, I have shares in the business, I have shares in that. So he has to trade, right? Or they could say, listen, we already have a house, and these heirs now, they could forego their rights, all right? They can do it, and you know what? You keep the house, right? You keep the house, and the other property, okay, we distributed according to the Sharia. This one, khalas, all our claims to that house, we will forego it. So listen, this is where the father comes into, listen, mention to the children, and you know what, and sometimes, okay, this is the request of the father, and this is what he wanted, and whatever, right? So they can honor that request, but there's not any legally binding upon them. Honor it, right? Just like, okay, man and woman get married, and the woman married the man with the condition, listen, if I marry you, you promise you will not take a second wife? He say, yes, I promise, right? And they get married. So then what the husband, what he should do? He should honor that request. But it doesn't mean that if he were to take a second wife, he's doing something that is haram. That is not legally binding upon him, right? But that is where tell the woman so that you should try and do that. Otherwise, if you do otherwise, you're not sinful. So these other siblings or children, if they honor that, good, alhamdulillah. And if they decide to do otherwise, that is their haqq and that is their right.
So the only way, if you really want to, let's say if I want to give one of my child that property, is to do it as a gift while I'm alive.
Yeah.
That will answer his question to our daughter.
About?
Our daughter, who who are looking after you and that kind of thing.
Yes, so listen, that's what in your lifetime. Listen, you have all this, right? Understand? According to what? The law of the land, or according to the Sharia, you don't need what? All these legal documents. Alright? So I mentioned something over here, but you need to understand carefully, right? If you don't want to what? Part from your property while you're alive, and everybody, I mean what? That's their right to, you know, always have it behind their mind. I wonder, you know, because they said if you sign over to your son, right? Everything to your son, you know that your son, khalas, would seek your interest, right? So you give everything to your son. If your son happened to die, then you being a father, you would just get 1/6 of everything else, right? That would go to his children and his wife, that property. And now you have no security, alright? Anyhow, so you want to give what? The property to what? Your children, right? Understand, this is what? You could do like this, and this is what I normally advise also, alright? Yes, no, these are the two people I want to give, my son and my daughter, nobody else, right? So two things you could do: transfer it in your lifetime, legally, and it becomes theirs, and you live in their property, which may not be the ideal thing, right? The second thing is that, okay, if you what, make a will that when I die, it go to what, my son and my daughter, right? And how you call it, 2/3, 1/3, that is a valid will, right? But what you could do also, listen, you can what? Gift that in your lifetime to them, right? Gift it now, verbally you gift that up, right? Without any legal documents, right? Without any legal documents, you gift that. You know how, and how you're gifting it? However you want to gift it, right? Son, you have a good work, right? And you have a house already, right? So we're going to give what? The daughter this house and whatever, right? So what you do, you gift that. According to the Sharia, you gift and they accept that gift, right? So now, according to the Sharia, that belongs to them, not you anymore, right? But legally, they can't kick you out of the house. Why? Because you have the legal documents, right? You understand? So you have the legal documents. So what you do now, you make a will. When I say a will, the last will and testament. That will specify when I die, right? This property, this house, right? They describe it, it goes to my daughter, and whatever go to my son, right? So a person will say, no, you're making a will for what? Heirs, that null and void. No, that is not what? A shad'i will you're making it. That what? You already give it to them, right? So this will here now will just allow the legal procedure to take place, the legal transfer, right? So when you die now, and this will, it will take precedence, so it will be legally transferred to them now, because while the law of the land will recognize, okay, I give you this and I give you that, and you know, you accept it, you don't recognize that. And if you want to transfer it to them legally in your lifetime, you have to pay what? Value that and pay stamp duty and tens of thousands you have to pay, right? And think about it, after you do that, you're living in what? Their house, right? But if you gift it, understand, you're still living in their house, but they cannot legally evict you from that house, alright? Right? And also what? Go back to the will, that which is what? Part of the net estate. You know, a person, he would like that, okay, when I die, this money go to this school, this madrasa, this one and that one. They're very good, alright? Understand, more money that goes to that will is lesser you get for the heirs. You understand, the net estate, you have what? The beneficiaries of the will, and you have the heirs. So if there's no will, then what? The heirs get all of that, right? But if you have a will now, that would what? Yes, the most you can go is 1/3, but if you have a will, right, bigger your will, more it would take from the heirs, right? So here the Prophet ﷺ, he mentioned, it is better to leave what your heirs, yani rich, right? Independent, than making a big wasiyah to fulan, and then when you die, your heirs have to go and beg. So everybody look at the condition of their heirs. If their heirs are dependents, right? Dependents is better to what? Leave that for them than to what? You know, make a big will to give this one and that one and that one, right? More money that will remain for the dependents, that is better, right? That is better. We're skipping out plenty of things here, but we're going. Right, listen, this is important, very important. Why a person, okay, many times, okay, this money would go to, he makes out a will and he has his what? His heirs, right? Son, daughter, this and that, but still, many times that person, what? From that 1/3, that was here, that will, he wants also that, listen, this money go for the building of that masjid, right? That hospital, or given khalas in a good cause, right? And he leaves this person in charge to do that, right? So why are you doing all of that? You're doing all that to get blessings when you die, right? Sadaqah jariyah, not so? If that is the case, you actually do it in your lifetime. If this is what you plan to do already, okay, when I die, this part, my children will not benefit from it. It will go to that good cause or that cause. And you put in what Zaid or Omar in charge of doing that. But you still have life. You do it now. This is what you call waqf and endowment. So that what sadaqah jariyah, that comes into your account while you're alive. And when you die now, khalas, it will continue. And who better to see about that than you? You want that for yourself. So you make effort to put that in place. Right? So take that portion of your wealth and put it for whatever good cause. Right? Whatever good cause, that will be what? That will only be continuous. Any jariyah means what? Perpetual means what? Jariyah, always what? Flowing. Always continuous. Right? That is what sadaqah jariyah. Flowing sadaqah. That is what? Never ending. Right? That will not cut off. So you invest in something like that. Waqf. You make that investment, that endowment, and that would ensure, listen, that even in your lifetime before you die, you get in that. Right? You sort of know that. When you die now, listen, understand here, right? When you die, there is no guarantee in that. Why? Because after a person dies now, and after you pay all the debts and this and that, the estate shrink, and what you wanted to do, right? What you want, that good cause or religious cause you wanted to do, is now more than 1/3 of the estate, of the net estate. So now that 1/3 cannot finance that. But in your lifetime now, if it is what? The entire estate is worth, you could do that as yours. Right? So khalas, when you're alive, that is your money. Do something good with your money before you die. No, when you're dead, it's not yours. And that's on the mercy of the heirs. Right? And then as you mentioned, it is restricted to that 1/3. And if it cannot be financed from that 1/3, khalas, that finished, your dream's gone there. Not dream, and what? You have no jariyah, nothing coming in. So you waiting for nothing coming in. You waiting for transfer. In barzakh, nothing coming in. Right? Because we didn't put things in place. Right? I mean, listen, if you open a business or whatever, we want to see that business run properly. We would just sit down home and send someone. No, we would go in that business, and if it day and night, we would to ensure that what? It running properly, right? And this business, how long will it last? A few years, right? Or probably until what? We retire. But look at effort we make in it. But if we want that business, right, that will bring in money, what? Continuously until what? Until Qiyamah, or for a long time. We have to put more effort in that. Right? Understand this concept of waqf, right? And this endowment. Understand it doesn't belong to anybody, right? For example, you have a building. Just say a building, you have anything, right? You have a building and they give that in waqf. And this building, you have what? Tenants renting that building, right? And the rent money from that now, it's going to what? The poor, it's going to the needy, it's going to, and this, you specify also, right? Yes, we'd have administration costs obviously to run it, right? And this whole building waqf. So this building what? When you die, it's not part of your inheritance, right? Waqf is what? To give something lillah, right? Give something lillah to what? Certain beneficiaries who would benefit from it and not own it. So when you die, know that this is what a trust then, right? In legal terms, a trust, right? So long as that building is what running, the rent that comes in, a portion will go for what maintenance, a portion will go for administration costs, and what the chunk of it would go to who you specify, to the poor in Barrackpore, or it would go to what students of knowledge, or it would go to what whoever you specify and you got in your lifetime. Alright, so when you die, know that building is what? Not inherited. It cannot be sold. It will remain. So that is the better what? Investment. Alright? Then when I die, do this and do that. What you do it now? And the next option also what? Instead of inheritance, they gift it. Alright? Gift it in your lifetime. Right? And the benefits of what gifting and endowment, what? You see the rewards immediately. You don't have to wait until you die to see the rewards. Alright? But we'll stop here. Any questions? I know this is the last class, but we still, any questions?
To continue the same topic next time.
No, let's finish off. Inheritance, finish. Right? The second part of this inheritance is actually what? The calculation, the distribution. Right? So that would be part of this classes here. But we would start with Janaza next year, inshallah. Burial, shrouding, laws of fasting, zakah, etikaf, inshallah. So any question in inheritance before we he said he sought out already. Right? Lion said he sought out already. بس طيب جزاكم الله خيرا. السلام عليكم ورحمة الله وبركاته. سبحان الله وبحمده سبحانك اللهم وبحمدك أشهد أن لا إله إلا أنت